I'm Anisha. I'm Anisha. I'm one of the summer interns at the Citizen Advocacy Center. I'm a rising junior at Harvard University, and I'm presenting on the Voting Rights Act of 1965. So, I'm going to start off with a little bit of historical context before jumping into a very broad stroke summary of what the act was when it was first enacted, then moving into the amendments and court cases that followed, and then finally wrapping up with what was kind of voting rights history in Illinois specifically. So, for some historical context, the Voting Rights Act was first signed into law by President Johnson in 1965, and it was seen as a huge victory for the civil rights movement and was very successful, as proven by some of these statistics, for increasing voter registration and turnout for all citizens across America. So in the bottom part of the screen on the left, the graph that you see, the before 1965, there was about a 44% estimated percentage difference between Black constituents and white constituents in voter registration. That dropped to around 11% after the Voting Rights Act was enacted, so around 1971 and 1972. So significant decreases in the estimated percentage difference. And then the graph you see, or the chart you see on the right, shows the white versus non-white registration percentages. And you can see from this graph, essentially there was a 22 percentage point increase for non-white registrations, as opposed, and for white registration percentages, it jumped by around 3%. So again, it helped everyone across the United States increased and successfully increased voter turnout and registration, significantly. So now moving into a summary of the act. The main section of the act was Section 2, which explicitly prohibited discrimination against any racial or language minority group. So that could take the form of gerrymandering, excessive documentation requirements, any voting devices or tests or taxes that are needed to actually vote. And in this act, there was also sections that established a coverage formula. So essentially, it was if you maintained prohibited tests and devices in certain jurisdictions and had a voting registration and turnout rate under 50%, you were considered a covered jurisdiction, which meant that the federal government had extra oversight on your jurisdiction. The federal examiners could maintain registration lists in your jurisdiction, and also these jurisdictions were required to seek pre-clearance before making any changes to their election procedure or policy. So overall, covered jurisdictions had a lot of federal government involvement. The act also explicitly banned voter suppression in the forms of like tests, devices, poll taxes, etc. So this act was very sweeping and was very revolutionary in its time, and kind of like what I said in the slide before, was a very big victory for the civil rights movement and for just increasing voter registration and turnout across America. So moving on into the amendments and court cases that kind of shaped the Voting Rights Act into what it is today. In my research, I found that there were three main sections of this. There was a wave of strengthening the voting rights movement, or sorry, Voting Rights Act in the 1970s. And then it shifted into a clarification of Section 2 of the Act. And again, Section 2 is the section that explicitly bans discrimination against any racial language minority group in all election procedure. And then, unfortunately, the most recent trend we're seeing is a weakening of the Voting Rights Act. So, to start, the first real test to the Voting Rights Act came in 1966 in South Carolina v. Katzenbach, where South Carolina was concerned whether the federal government could have the power to be so involved in state election procedure. And the court ruled that it was allowed, and it kind of confirmed the constitutionality of the Voting Rights Act. In 1970 and 1975, Congress passed more amendments to the Voting Rights Act, extending expiring provisions, including more up-to-date participation data to be included in what would be the criteria for the coverage formula, so deciding what would be a covered jurisdiction. It lowered the national voting age to 18, and then also just generally expanded language accessibility requirements across all voting jurisdictions. And then moving into a clarification of Section 2 in the 1980s, in Mobile City v. Bolden, there was an election where the results of it were racially polarized. And so challengers of that election essentially said or claimed that this was discriminatory because of the effect of the election results. The Supreme Court, however, ruled that the election did not violate Section 2 of the Voting Rights Act because the challengers couldn't establish an intent of discrimination as opposed to an effective one. In response, in 1982, Congress passed another amendment to the Voting Rights Act that essentially said that a Section 2 violation can be established if a challenger can prove either a discriminatory intent or a discriminatory effect based on a totality of circumstances, which can include a history of discrimination, racial appeals in political campaigns, etc. So there was a broad definition of what that meant. In the 1982 amendment, they also continued extending the pre-clearance sections for another 25 years, and also added more protections for blind, illiterate, or disabled voters and allowed them to receive election assistance. And then in 1986, in Thornburg v. Gingles, there was another court case that essentially established an evaluation for voter dilution claims to be essentially that a minority group is geographically compact, votes as is politically like-minded and generally votes for the same party or candidate, and that the majority has the power to block the minority vote. Then moving on into the most recent trend we see with the Voting Rights Act, which is a weakening of it. So in 2006, while Congress passed another amendment to the Voting Rights Act, extending language accessibility provisions, but weakened the act by repealing the sections that appointed federal examiners to observe and maintain registration lists in covered jurisdictions because they deemed it unnecessary now, and also didn't update the census data or the data in general to that was used in deciding what would be considered a covered jurisdiction. And so, because of that, in 2013, in Shelby v. Holder, the Supreme Court invalidated the coverage formula and all of the provisions that came with it because it wasn't using up-to-date information. And so it took away, for example, the section that required these covered jurisdictions to receive pre-clearance before making changes to election procedure. So it invalidated a lot of sections in the Voting Rights Act. In Bronovich v. Democratic National Committee in 2021, there were also other ballot policies in Arizona that largely had a adverse effect on minority groups, and the Supreme Court ruled that these procedures did not establish an excessive barrier to voting, despite the adverse effect it had on minority communities mostly, as opposed to the population in general. And then the two more recent ones, Alexandria v. South Carolina State Conference of the NAACP. In this one, there were challengers who said that the redistricting maps diluted a lot of minority votes, but the court ruled that it did not because the challengers couldn't prove that the map was motivated by race rather than politics. And this is hard to kind of disentangle because race and politics are naturally so intertwined. And so that just made proving voter dilution claims even harder. And then most recently, earlier this year in Louisiana v. Callis, there was a voting map, a redistricting map in Louisiana that a lower court ruled had diluted the vote of certain minority groups. And because of that, the Louisiana had to redraw its redistricting map, essentially being conscious of making sure that the minority groups were represented and were not their votes were not diluted. And so challengers to this redrawn map essentially said that there were racial motivations in designing this new map, and so it was a violation of Section 2 of the Voting Rights Act. And the court ruled in favor of the challengers and said that to prove that an original map was drawn with racial motivation, you have to prove that a map was drawn with racial motivations as opposed to party affiliations. And just as a side note, drawing maps that are partisan or are based on party affiliations is completely legal. And so this made proving discrimination against minority groups in election policy, procedure, and maps even more hard. And so in this ruling, the court also said that it kind of weaken the definition of totality of circumstances to prove an intent of discrimination, essentially saying, for example, that a history of discrimination does not count and is not considered evidence enough to prove potential racial discrimination in election procedure. So, as a result of these court cases, the Voting Rights Act has kind of been essentially kind of gutted and weakened a lot. And so the decision to protect voting rights has kind of fallen to states more specifically, as opposed to deferring to the federal government. So, because of this, we see a large effect in what states are doing in terms of defending their voting rights or kind of changing the procedure or maps. And so, in states like Illinois, California, New York, and Colorado, we see that they have or are planning to expand their Voting Rights Act, statewide Voting Rights Act. And so, I'll get more into the Illinois specific one, but essentially, a lot of states, like the ones I had just mentioned, are expanding kind of enacting what the Federal Voting Rights Act was like when it was first enacted in 1965. So we're seeing that trend for a lot of states. Another kind of opposite trend that we're seeing in a lot of states, including Louisiana, Alabama, Tennessee, and Florida, is kind of redrawing redistricting maps that are highly partisan. And because, like I said, race and politics are so intertwined, what happens is that it tends to have the effect of voter dilution on a lot of minority groups because of these partisan maps. And so there has been a shift in a lot of states towards that as well. And so the disparity between voting rights in certain states versus others is great, as given that the power of voting rights is largely shifted to states now as opposed to the federal government. So those are kind of the effects that in my research I saw in Louisiana v. Callis in that ruling and will likely affect the upcoming 2026 election cycle. Now, moving into Illinois specific voting rights, just as a general overview for how redistricting procedure works, in Illinois, the legislature or General Assembly first comes up with a map. If they're unable to do so, there's a tie. It goes to an eight-person bipartisan commission. If there's a tie in that commission, it goes to a tiebreaker selection where the Supreme Court submits two names from each political party, and the Secretary of State randomly selects a name, and whoever's name is drawn picks the map. And a fun fact about that is that the name is actually drawn from a replica of Lincoln's stovepipe hat. So just a fun fact. And then in terms of court cases in Illinois, in Hastert v. State Board of Elections in 1991, because of the rise in the Latino population then, there was a court-ordered kind of minority group that was drawn for the Latino community in their redistricting map to make sure that their votes weren't diluted. And so, because of that, the map that was drawn, or the redistricting map that was drawn in Illinois, took into account this kind of court-ordered mandate. And challengers of this of this drawn map essentially said that the map was drawn with racial motivations in mind. And the court ruled that essentially it was in response to a potential Section 2 violation. And so it didn't count as a violation of the Voting Rights Act because it was court ordered. And so this is kind of the exact opposite ruling that we saw with the Louisiana v. Callis ruling. And then in terms of legislation in Illinois for voting rights, the one that's currently enacted was enacted in 2011, which essentially requires the state legislature in maps to create crossover coalition and influencing districts and kind of defers all other election related procedural decisions to the federal government and the state and federal constitution. The one that's currently on the floor and will likely be picked up when the General Assembly meets next is the Illinois Voting Rights Act of 2026, which is much more expansive and is meant to kind of shield the state's voting rights privileges kind of from the Callis ruling. And so, more specifically, on the 2026 Illinois Voting Rights Act, it accounts for all levels of government, so anywhere from local municipal governments all the way to the state government. It requires either an intent or effect of discrimination to trigger a redrawing of an electoral map. This is different than the 2011 Voting Rights Act, which deferred this to the federal government. And as we've seen from the Louisiana v. Callis ruling, we saw that an effect of discrimination is no longer considered enough justification to redraw an election map or change an election policy. The 2026 Voting Rights Act also explicitly prohibits voter suppression in various forms and also any election method that has the likely effect of voter dilution. So that can be at-large elections, district-based elections, etc. It also strengthens and defines the definition of totality of circumstances to be a history of racial discrimination, also kind of representation of minority groups in the government already, etc. So it just kind of strengthens that definition. It also includes an enforcement clause allowing the Attorney General or anyone or organization to challenge any electoral process, expands language access requirements, and also requires substantial evidence by the state to justify stricter election policy if there are concerns for voter fraud. So all in all, this is much more expansive than the 2011 Voting Rights Act and very much brings kind of voting rights privileges to the state and allows the state to have jurisdiction over it. And so this bill is kind of currently being discussed, is on the floor, and has not been enacted yet. But again, like I've said, is much more expansive in its provisions. Yes, thank you so much. Hope you enjoy the presentation.